All right. Welcome everyone to Understanding the Basics of Cleaning Green Separations and Split-offs, Leasing, Subdividing, or Selling Enrolled Land. My name is Audrey Thompson. I'm a staff attorney here with the Penn State Center for Agricultural and Shale Law. Today's webinar is part of the Center's Understanding Agricultural Law series, a course designed to provide subject matter literacy and competence on fundamental issues of agricultural law to attorneys and business advisors who work with or represent agricultural or rural clients, but who may not necessarily specialize in agricultural law. And I'll pause here just a second. Looks like we're getting the sound. Okay, we're getting the sound issues sorted out. Great. This series is wholly sponsored by the Pennsylvania Department of Agriculture's Ag Business Development Center, established through the 2019 Pennsylvania Farm Bill. The Agricultural Business Development Center aims to enhance the long-term vitality of Pennsylvania farms by supporting farm transitions, both from generation to generation and from conventional to organic farming, supporting beginning farmers, providing risk management education, and providing financial assistance through low-interest loans and grants. Next slide, please. As you can see here, we've covered numerous topics so far, including Ag Labor and Fair Labor Standards Act, Ag Cooperatives, finance and the farm credit system, crop insurance, conservation programs. This is the second Clean and Green program. We have a intro one before and many others. You can find materials and recordings from all of these webinars on our Understanding Agricultural Law landing page on our website at aglaw.psu.edu. Next slide, please. Upcoming topics in our Understanding the Basics of Ag Law series include organic production in March, and then producer protections for buyer default on April 26th. Those are both on Fridays. They're at noon, and registration is up and available. And then I'll give you a sneak peek in May. It's going to be a conservation easement issues seminar, but we're still sorting out exactly what issues we're going to do. And then in June, we are workshopping a Chesapeake Bay webinar. Stay tuned for that. And then also I'll mention our Dairy Quarterly webinar in April there. And then in March, we're partnering again with the Pennsylvania Agricultural Ombudsman Program to offer another ACRE presentation that will include Robert Willing, the Senior Deputy Attorney General from the Pennsylvania Office of Attorney General, and then Robert Meinen, the Assistant Research Professor with Penn State Extension, and our own Senior Staff Attorney, Brooke Duer. That will be in person at the U.S. Hotel Tavern in Hollidaysburg. If you're available, please come out and join us that day. It's going to be a great program. All right, I will now turn this webinar over to Brooke Duer, the Center's Senior Staff Attorney. Brooke joined the Center for Agricultural and Shale Law in 2019. Prior to coming to the center, he served as Chief Counsel to the Pennsylvania Department of Agriculture, and before joining PDA, he practiced law in Lancaster County for 18 years. Brooke, the screen is yours.
All right. Thanks, Audrey. You're getting my shared screen correct and my audio? All good?
That is correct, yes.
All righty, good. Okay, so here we are. Here's our topic, Clean and Green Separations and Split-offs. And this is... again, it's a drill down topic. In other words, we're going to now start. We've gone for about 2 years almost with this program, doing an understanding level, a 101 kind of level of each of our topics. Now we're going to start to begin some deeper dives here. So this is our first one. And again, here are the links on this screen for the previous one that was done almost to the day 1 year ago. In fact, we get a little, if you take a look at the transposition of the numbers here, we last did it on 2/23 of 24. Now it's 2/24 of 23. No, excuse me, other way around. So now let's do a recap of that particular program very quickly, and then we will get into the new substance. All right, just a quick one too. Audrey had mentioned that we have virtual resource centers on our website, and here is our virtual resource center for Clean and Green. And and there's all kinds of information in here, the statutes, obviously, and then case law. There's also in the related publications tab, there's information from the various different counties, as well as some legal publications, law review notes and articles and things of that nature. We're always sort of in a process of continually updating these. And if you find things and you know of things that you think would be good to have reflected in these virtual resource rooms, whether it's our Clean and Green one or any of the other ones, please send them on. And that's why we have this contact person information down here in the left sort of bottom side of the homepage of each, so that people can converse with us and communicate with us about the content of them. So now, just the overview again. These are mostly slides that might have a little bit of tweaking, but that I used the last time a year ago when we did our 101 sort of version of this. Obviously, here is the statute is, of course, not called Clean and Green. It is called the Pennsylvania Farmland and Forest Land Assessment Act. It was enacted in 1974. And there's two links here, one to the standard, I think this is a Westlaw link, and then here's one that's to a easier to read version of the statute that is actually housed on the PDA website and prepared by the wonderful Dwight Smith, who I worked with for many years and miss dearly. And the regulations, same thing. We have, the formal version, the PA code website, as well as Dwight Smith's nice little easier to read version. Just to give you the perspective, if you're not aware, 60 of the 67 counties in Pennsylvania have clean and green programs. It is a voluntary program that counties can decide not to have if they don't wish to offer a reduced tax assessment for ag and forestry properties. And we'll go over all of that. And here's a little list of the counties that don't have programs. We'll talk about that. I have another slide on that in a second. And, there are limited administrative duties that are performed by the Pennsylvania Department of Agriculture, but if there is any place where there's a clean and green home in the state, that it's their website. It all falls under the Bureau of Farmland Preservation. Stephanie Zimmerman, of course, is the Bureau Director now, with Doug Wolfgang having moved up to the Executive Director position at the State Conservation Commission. And Stephanie has a person who is directly appointed to just be dealing with clean and green issues. And it's quite an interesting thing because it's basically interfacing with 60 different county assessors' offices. And they all have their own views and they all have their own practices. And it is really 60 different programs in the state. They operate under the same statute, but there are differences from county to county, and sometimes the only answer to a question is you're going to have to find out that, or address the question to the county to find out, because there are some differences, and in some pretty significant places sometimes where the differences from county to county are. Just to recap, the authority for having a differential tax assessment for ag-related properties, and we'll get to the definitions in a second, is in the Pennsylvania Constitution, and this is the actual language. So this is one of these rare occasions where we have an authorized deviation from the uniform taxation that requirements of the Pennsylvania Constitution, which of course lead to a good bit of litigation in and of themselves. The basic overview continuing on here is that of course the statute allows land taxation per its value as used, or in other words, a use value, rather than its fair market value. So enrolled land is assessed per the income approach to land appraisal, and the amount of income that the land can produce. Oops, excuse me. I have a tendency to do that sometimes. There we go. As ag or forest use. And again, we'll go to the categories in a second. You probably know there are 3 different categories under which you can enroll land: ag use, ag reserve, and forest use. Right now, the data we have is that in 2022, the Bureau of Farmland Preservation's annual report shows that there are 10,917,928 million acres that are enrolled in the program, and there are 215,866 separate parcels. That's pretty robust. For a state program, that is quite a success story. This may be one of the greatest success stories, in the history of sort of Pennsylvania's legislative. I don't want to say the word promotion, legislative efforts to ensure the continued viability of farming in the state. And, this is just such an impressive number and always has been. And the average reduction in fair market value assessed value for enrollees is roughly 50% reduction. That's averaged across the 60 counties. It's different in different counties, depending on how recent they've done a reassessment and where they stand in that whole process, which don't really want to touch that here. Obviously, that's somewhat of a lightning rod, in various parts of the state. So, an average of 50% reduction is quite something. Okay, here are the three categories for enrollment, of course. And enrollment, by the landowner is voluntary, just as the county's offering the program is voluntary. Requires the basic minimum of 10 acres. However, there is a little asterisk next to that, and they're in the ag use category. You can have less than 10 acres if you have proof and it's documentable that you are engaging in activity which is capable of producing greater than or equal to $2,000 in annual farming income. So not a giant high threshold if you have less than 10 acres. So and there's about a total of something in the neighborhood of 4.3 million acres that are enrolled in the ag use category. That is obviously, although if you look down here, Forest Reserve has more enrolled acres. Ag use is really where a lot of the attention gets paid, but very vital to, the forest landowners of this state also. And then you have, so Forest Reserve again requires the 10 acres, doesn't have any exception for an income threshold. And then you have agricultural reserve. This is obviously, or maybe you're not aware, but this is a bit of a lightning rod in the entire scheme of things with regard to cleaning green. And, the formal definition, non-commercial open space land used for recreation and scenic enjoyment that is open to the public, free of charge. There's a total of approximately 600,000 acres enrolled. A residence or a farmstead or, is always allowed in all three categories. Now, depending on individual county choices, that farmstead sometimes doesn't get the preferential tax assessment just on where the buildings are, so to speak, and the curtilage around it. But what this agricultural reserve category leads to, of course, is that you can live on this property, and I don't want to make light of it, but that's what's led to the controversy in the agricultural reserve category of what I would just call here the McMansion problem, which is people who live on properties that are more than 10 acres, not necessarily engaging in anything in the way of capabilities to produce timber or wood products, nor engaging in anything that has anything to do with agricultural commodities, basically just living there on a beautiful home and enrolling. And there is a lot of sort of legacy of enrollment in situations where there probably is not recreational use being made of that land, and that it is not free of charge to the public. That's a hot, issue and bit of a sore spot, and that's something that maybe we'll address some other time in the future. Don't want to get bogged down in that now. That is certainly one of the things that detractors of the program, like to point to. Now, which counties don't offer it? Here's the list. And you see Philadelphia not on there. Although we don't have any data from Philadelphia, and I really have never plumbed the depths of whether Philadelphia has any enrollment, they are not on the formal list of those who don't have a program. So I'm assuming that means they do. It's been a bit since I was at PDA to remember any of the ins and outs of that. Now, most of the time, we'll look at a map here. Most of the time, the reason why a county doesn't have a program is because their assessment is so old that if they were to use the use values that come from, and they're published by the Bureau of Farmland Preservation at PDA, and on an annual basis, and there's a long, complex process that establishes those. Don't want to get into that now, but the bottom line is, those are updated yearly. A 30-year-old countywide assessment, is not. So many of these counties who don't have programs, it would actually, potentially might be an increase in, tax assessment for certain people in certain properties. Now that's changing obviously as we continue to have reassessments and countywide assessments being done all over the state, and so that's a whole issue into itself. But generally, that's why a county doesn't have a program. The other thing to just remember about this program, it's not without its controversy arising from what I have on this slide, which is that, a county's voluntary election to have a program means that they've chosen to forego imposing and they therefore transfer some portion of the gross real estate tax burden necessary for whatever the county's government's needs are from clean and green enrolled lands, which are getting a reduced preferential tax assessment, to all the other land in the county. So that necessarily does not sit well with some. But this is clearly a policy choice that 60 counties in our state have made, dating back to the enactment of the statute in 1974. Extremely popular program, extremely high participation, let's just say. And overwhelmingly, the policy choices in this state have been to offer this and to continue to maintain programs. The more property that's enrolled, results in either a reduction in gross, county real estate tax revenue or an increase in property taxes on, properties that are not eligible to be enrolled. And of course, it's primarily school taxes, as we know. And so, the program is not without its detractors on that point also. However, other than, those two things, the other issue about, the ag reserve category, we have a wildly successful program here that the state has been operating for, at this point, what's that come to, 50 years, almost. Okay. Now, big feature of the program, of course, is the concept of rollback taxes. Meaning that when you enroll your property, you enroll it in one of the three uses, and you have to qualify for the terms of the statute, describing those various uses. It's got to be the 10 acres, as we talked about, or that smaller income threshold for smaller properties for in ag use, and then other criteria. And if you in some way, shape, or form do something that renders your land no longer eligible or ineligible to be enrolled. And that can be because you've gone under 10 acres total, or it can be because of what you are doing on the property. So many times when you talk about a change of use, or when people talk about a change of use, sometimes that just means it's no longer 10 acres. It's only a 9.5 acre lot for some reason. A half acre was in some way transferred out. And then you lose your eligibility there, just the same as if you had changed the use of what you're doing on the surface. So when we say change of use, sometimes that also encompasses the concept of the dimensional changes, that the number of acres and the size of the enrolled parcel has gone under 10. Okay, just wanted to sort of alleviate that sort of confusion sometimes, because it can get a little sticky when you start going through and working with the statutory language. So again, change of use that results in a rollback tax, which means that you get a bill from your assessor that says, pay us the last 7 years worth of tax savings that you have realized by being enrolled in this program. And if you haven't been in the program for more than 7 years, then it's going to be whatever tax benefit you've realized to that point. Plus 6% simple interest. That money actually goes into the fund that ultimately goes towards purchasing agricultural conservation easements. That's where the interest goes. And the land is, not only do you pay the rollback taxes, but of course the land for the future is removed from the program. Now, sometimes, depending on the circumstances, only a portion of the land will be totally ineligible to be re-enrolled, and a big chunk of it may be re-enrolled. So then that varies depending on circumstances. So we'll get to that in a little bit, talk about some of that. Now, certain subdivisions, and this is what we're here to talk about, certain subdivisions and conveyances and transfers, something that actually is an interest in the property, and we'll talk about leases too, that is being in some way, shape, or form conveyed. That's kind of what we're here to talk about. What another subject that we're going to talk about later in a drill down will be use that is being allowed on the property that does not have anything to do with actually granting legal interests in the property, let's just say. So this is, again, all about separation, split-offs, leasing, subdividing, alienability of the land, shall we say, and how that is impacted, and how and what, a general practitioner, for example, without experience might need to have a basic understanding of the details of some of that. So anyway, so there are two kinds of conveyances that are of primary importance in the statute, and what we're here to talk about: split-offs and separations. We'll talk about what those mean in a second. Bottom line is split-offs bad, separations good. That's essentially. Split-offs generally mean you're going to get a rollback. Separations generally mean you're not. And we'll go to the definitions in a second. There's also a big exception. This is one of the things about talking about uses on the property that may be allowed, or maybe that we'll do in a later drill down session, sometime in the future in this webinar series. And that's where you get into all these issues about what kind of activities can you do on the property that may not be the actual growing of agriculture or the production of agricultural commodities. And that's generally lumped into this category of rural enterprises. That's the term under the statute for it. And, there are many, many exceptions to, those use criteria for what's going on the surface of the land. There are many ways that you can engage in other activities also. And rural enterprises is one of those. Again, that'll be a separate drill down topic someday. All right, keep going here. Now, enrollment restricts the land's use and alienability. We talked about that. Landowners' acceptance of the tax reduction carries this obligation that you have to maintain all the acres enrolled together in one application. That's a very important concept to this entire program. Whatever you enroll together in one application, one submission to the county assessor's office, becomes a unit which is dealt with as a unit. So they may be separate deeds, but if there's 30 acres on this deed and there's 75 acres on this deed, and you enroll them together, that's 105 acres that has been enrolled in one application and sort of becomes the enrolled tracts, plural, for the purposes of administering this law. That may be something that you need to be thinking about, particularly if you have someone who's new and just enrolling, because enrolling separate tracts separately can be advantageous to the landowner, as opposed to, and we'll talk about that. Basically, it's because of the rollback potentials. We'll get, and I'll have some explanation of that here. It's the caveat on this very slide. So these obligations to maintain the acres, in conformity with all of the requirements for the qualifying use, whether it was ag reserve, forestry, they theoretically exist perpetually. The obligation runs with the land. So you can sell the property, it just remains subject to, the clean and green requirements, and would be subject to a rollback if, things change, if there are changes made in the use, or the dimensional, the lot sizes. Now, in 2010, that changed. There is a way to voluntarily ask to be just let out of the program on your own volition. Before you've done anything that might change your status and cause you to have a rollback. Now, you're going to pay, but there are times when legislature heard from enough people that the ability to remove yourself voluntarily from the program, which did not exist for the first 40 almost 40 years of the program, now does exist. Kind of changes things. Now, the cost of a rollback tax and removal is sometimes just considered to be, hey, that's part of the cost of doing business. And, for example, if some, solar electricity generator wants to come in and put up solar panels on, 30 of a farmer's, 500 acres, the paying the rollback tax on those 30 acres, for example, maybe just considered the cost of doing business for that solar developer, and they just factor it into their, economic equation to see if the balance sheet's still looking good. Yes, that's certainly, that is out there now, and it is there is a way to voluntarily just withdraw from the program. Again, didn't used to exist. Okay, so sometimes, it's done intentionally. To essentially, either ahead of time or what. Now, one of the things, and I'll get to it in a minute, but one of the things that happens when you voluntarily withdraw is that the same owner cannot re-enroll any land. So in other words, if that farmer example that I was giving you, which is, farmer's got, I forget what I said, 300 acres and you're going 30 acres to, for some solar panels. If you didn't do a voluntary withdrawal, no, I shouldn't even say that. I'll put it this way. The circumstances are such that you're going to pay the rollback taxes if you enrolled the full 300 acres, and then you can re-enroll the balance, the remaining 270, and the solar developer hopefully is paying for all that. However, in the case of a voluntary withdrawal, you can't actually re-enroll. So only a subsequent owner, not the same owner, only gets to withdraw once, and then that's it. That land while it stays in their ownership, it is forever unable to be re-enrolled. So there are the pros and cons to how you go about doing things if for some reason you basically want to intentionally get out of the program. Leave it at that. Now, again, the caveat, I've already sort of explained it. If the enrolled land was 100 acres, a change to an ineligible use in some way of even 1 acre means you get a rollback tax bill and a removal from the program of all 100 acres. And again, just to be clear, there's 2 ways that happens. Either it happens through the voluntary process that now exists in the statute, which bars that same owner from re-enrolling. Let's say that this scenario came to pass. 100 acres, 1 acre violates. You got 99 left. You want to re-enroll them. Well, if you did the voluntary program for withdrawal, you actually cannot re-enroll those 99. At least that original owner can't. So, in any event, the trick is not how to get in the program, it's how to stay in the program once you're in it while you still exercise the rights that accompany your land ownership. And it can be a bit of a minefield. Try to give you information to understand that minefield better. Here's the provision on voluntary removal. A landowner may voluntarily remove their land from clean and green by notifying the county assessor by June 1 of the year immediately preceding the tax year for which removal is requested. Rollback taxes are due upon the submission of the request, and it's on all the enrolled land, and then the removed acreage may not be re-enrolled by the same owner. So that is a penalty that makes this process, potentially still, have drawbacks, apart from, of course, the money. This has only existed since 2010. And there are some data that the Bureau of Farmland Preservation has in its annual reports that sort of break down a little bit of, how much of that is actually going on. Now, so the overall concept, and then we're going to dive into split-offs and separations. Clean and green is riddled with exceptions to every rule. And you know what? That's why it works. Without all these exceptions, this law, would be really simple, but it would also be really burdensome. And as a result, it would never be as wildly popular as it is, and wouldn't be utilized to the massive extent that it is. And the net, benefit to the viability of the continuation of ag, as a livelihood and as our food source would not nearly be, as advanced as it is without these exceptions. That's the kind of the facts of life here. It's the exceptions written into the law that essentially make this law work, as well as it has. And it is, as I put on the bottom of this slide, it is considered the fundamental tool in Pennsylvania's efforts to prioritize farmland preservations. This is tool number one. Now, let's talk about split-offs and separations. Here's my joke at the bottom corner. You probably remember Frankenstein, the movie, or maybe even the parody Young Frankenstein. Split-offs, bad. Separations, good. And I think there was even a Saturday Night Live skit with that one. But the bottom line is, that's the way you can keep them straight. Split-offs, bad. Separations, good. Split-offs. What's a split-off? A split-off under the law is, and the reason why these terms even exist is because then there are little ins and outs of what the kind of rollback you get if you get one, and other things, with regard to how you go forward, so to speak. Now, a split-off is a division by conveyance or other action of the owner. And there's a case on that, actually, which we're going to talk about later, of lands that are devoted to ag use, ag reserve, or forest use, and preferentially assessed under the provisions of this act. In other words, a division by conveyance or other action of the owner of land in the program, and here's the language, into two or more tracts of land, the use of which on one or more of such tracts does not meet the requirements of the law. Okay, so any, may not be, you may have conveyed into 3 parcels, and maybe 2 of them are fine, but one of them is less than 10 acres. That's going to be a split off, and that's an impermissible split off in the sense that that will result in a rollback. So that's why we say split off's bad. Separation's good, because here's the definition of separation. Same language, a division by conveyance or other action of lands in the program. Here's the operative language, into 2 or more tracts, the use of which continues to be agricultural use, ag reserve, or forest reserve, and all tracts so formed by that separation meet the requirements. So in other words, you're just splitting up a bunch of property that is continuing to qualify for the program. We'll get to this in a minute. I'm going to leave that aside. I was going to start talking about the dimensional issues, but let's just leave it there for now, and I will get to that in a second. So again, split-offs are what cause problems. Separations are the things that are generally permitted. As you can see why. In separation, the exact thing that the governmental benefit that is being given to the landowner is being honored. And they are doing what's required, or what is required by the landowner or landowners, because perhaps in a separation, somebody has taken over the property or a piece of it that has been separated. They're continuing to do exactly what this program required from the day that the property was enrolled. And so, again, these are conveyances. Generally, you're going to have some new ownership going on in here. And, so in other words, you have a land enrolled in Clean and Green, you can sell it, and it's the Clean and Green enrollment runs with the land, stays as part of the title, stays as part of the owner's obligations. It can be transferred 10 times. And, that's fine. As long as the program terms are being complied with, the tax parcel number, still gets its preferential tax assessment, regardless of the name change from 10 transfers or whatever it may be. It's when you have these transfers and then some type of activity occurs that renders one or more of them ineligible, like they're smaller than 10 acres, or you've changed the use on top of the land, whatever it may be. That's when you have your problems. Okay, now, this is the section that matters, 5490.6. So for you lawyers out there, this is the section, and I got links to everything here. This section is insanely complicated to try to read through. It's a labyrinthian section, but of course it's tax code, so no wonder. The title alone is basically a string of like 40 words and phrases that, it's just this. Where do you see a statutory section where the title is this long? Take a look at it someday. It's this big run-on, jumble of words, because this is where all the exceptions get jammed in. Now, it's been amended 7 times, twice in 2010 and twice in 2011. It was and what was going on in those years? Gas drilling. So this was a lot of issues paying attention to, the production of natural gas, or I should say maybe the exploration and extraction of natural gas on lands that were, you look at the map again that I showed you before, the entire northern tier, you got lots, or I should say, if you know where the Marcellus Shale is, then you can look and see which counties have quite robust programs. So a lot of this land was in fact in the program. Okay, so we're going to walk through this step by step. First of all, and again, hate to like dangle something out there and yank it away, but we're not going to talk. We'll talk a little bit about the exploration and extraction of natural gas language, and whether that's a change of use and what kind of rollback you get. So I will actually talk a little bit. Okay. So split offs, bad, equal rollback. All right, here's your section. The split off, basic, provision. The split off of a part of land which is subject to a preferential assessment under the Act shall subject the land so split off, meaning the piece that's been removed, and the entire tract from which it was removed, to rollback taxes. Get your bill for the last 7 years worth of tax benefit, pay it back to the government now. So again, same scenario as I was laying out before. You got 100 acres and you change the use on 20 of them, but you're going to get a rollback for all 100. And this is what goes back to this whole idea of how do you package your parcels if you have more than one. In an enrollment application, it can serve people better to hedge their future, obligations here by enrolling parcels separately. This program didn't begin that way, and so a lot of people have enrolled, thousands of acres on joint applications where everything is put in together, and that, in today's world, may end up being, a little bit of a drawback. Now, the landowner who conducts the split off shall be liable for payment of rollback taxes. Okay, so that, makes sense. In other words, if you're splitting off some little section of the property, it's the party that is responsible for, having conveyed that property and presumably got money for it, who is liable for the rollback taxes, except, once again, there's exceptions, and we'll go over that. Okay, so standard rollback, we already talked about that. I will skip this one because we've beat that one into the ground. Now, there is an exception, an allowance for split offs. Of course there is. It's clean and green. What I'll call the 2-acre residential lot allowance, which means, and here's the section and everything, it says, if one of the following provisions apply, rollback taxes shall only be due as provided in this section. So the standard language was what we had before, here, back here, and now here's the exceptions beginning. Okay, the tract or tracts split off do not exceed 2 acres annually. So you get this 2-acre residential lot allowance. Now, what you get is a rollback on the 2 acres, not on the whole thing that you enrolled together. So you're getting a break for these little pieces. And I got a nice photo that shows you exactly why all this works and how much you see it everywhere. You just never knew what you were looking at. Now, now there is an exception. If you are in a municipality that has a 3-acre minimum lot size for the district that you're in, you can get up to a 3-acre residential lot allowance. Okay, that's what this language in here in the middle of this paragraph says. Okay, but also take a look at this language. It talks, okay, tracts split off do not exceed 2 acres annually. And then it says, other next requirement, the tract or tracts split off are used only for agricultural use, agricultural reserve, or forest reserve. And then stop there for a second. Well, that sounds a lot like a separation. That's just like a, in other words, you're saying, this land is still going to be used completely and totally consistent with the program terms. It's just going to be less than 10 acres. So we'll talk about that in a minute. That's not the 2 acre residential lot allowance. I have a different word for that one. And this is what the 2 acre residential lot allowance is. So it's 2 acres, not exceeding 2 acres annually, for the construction of a residential dwelling to be occupied by the person to whom the land is conveyed. It's just selling off a building lot so that you can, have a little bit more income to keep your farm going. Now, there is a total sort of lifetime, I hate to use that word because it's not used anywhere, but there's sort of a cumulative total of your ability to utilize this little allowance for split offs, however. The total tract or tracts so split off over the history of this land's enrollment under that one application do not exceed the lesser of 10 acres or 10% of the entire tract subject to the preferential assessment. In other words, that's like your lifetime limit. You can do this up to the point where you've done a total of 10 acres already, and then you're exhausted and you can't, your limit is exhausted. Or if you've done it for 10% of the total enrolled land, you are exhausted. Now, you can see how that might argue for rolling more land together, because you're going to get a larger allowance for this sort of thing. 10% of 100 is obviously smaller than 10% of 500. So maybe you want to roll the 500 acres together. Well, those are decisions landowners have to make. But now also split offs that happen by condemnation, like a little tiny piece goes off for some, project of some kind, sewer, roadway, whatever it may be. No rollback taxes of any kind. That's it. It's your clean transaction. You don't get penalized in any way, shape, or form. Nothing is kicked out of the program except that little tiny, piece that maybe the sewer authority took. Okay, now, here's a description of what the modified rollback is. In other words, the rollback is each tract that has been split off shall be subject to rollback taxes. The landowner, in other words, just the little split off piece. Oops, sorry, wait a minute. The landowner who conducts the split off shall be liable for payment of the rollback taxes. We talked about that before, which shall only be due with respect to the split off portion of land. Hey, look at that. A sentence in the Clean Green law that actually reads, normally and you can make sense of it. This might be one of the only sentences in the law that is this clean. If the owner of the tract, which has been split off under paragraph 1, that's the section we're talking about, subsequently changes the use of that land, in other words, the person who bought that little residential building lot that was less than 2 acres, if they change it to an ineligible use, the owner of the original tract, which continues to be eligible, the rest of their land, shall not be liable for any rollback taxes triggered as a result. In other words, it's just cleaning it up to say this was sold as a residential lot, and so if they go ahead and build the house on it, you're not going to get penalized. That is not an event of rollback, because this is an allowed split off. It's allowed because number one, it's smaller than, it's violated the terms of the program because it's less than 10 acres, but it's also violated the terms of the program because it's being used for a residential home without, any other thing that ties it to the program, no agricultural use, no forestry use, etc. So this just clarifies what should be sort of obvious. Okay, so anyway, back to this is what I'm talking about. This is all you need to know to understand the 2 acre residential lot exception, the split off exception for residential lots. Here's the farmer, here's his farm, and the road frontage is all sold off. And you got to, and not only does this happen because this is how zoning ordinances and how municipal law makes it most convenient to generate some income by selling building lots, you need the road frontage. But this also is evidence that it may very well have been done one at a time. I don't know whether this totals up, 10 acres or not, or 10% of the enrolled tract, because we can't really tell. But when you drive down the road and you see this, and you see the farm in the back, and you see all the fields right there that start right at the backyards of everybody who lives there, chances are the whole reason that exists in that condition is because of the clean and green statute. That's it. You see it everywhere. And not only does it make logical sense without the clean and green statute, it's basically required, under the clean and green statute for this farmer to maintain their preferential assessment on all this land. Because we'll just make an assumption that probably when this was enrolled, let's say, I'm just, giving you a graphic and as a hypothetical here, but this land across the front, the road frontage, was probably in the enrolled land. And then systematically, these little building lots, 2 acres a year, were sold off. Up to, of course, the sort of that lifetime limit, so to speak. And that's what it says up here on the top of the slide. So that's a graphic example. Now, here's the other split off exception, which is 2 acre split off for an eligible use. This was the other thing I was talking about, which is this one's kind of buried in the law. Doesn't get a lot of attention. Note that this same statutory text allows an annual 2 acre split off, provided that the split off parcels remain in an eligible use. This is the equivalent of an allowable 2 acre separation. Okay, so it's meeting all the terms, it's just not 10 acres. So the same rules apply, which is that this the rollback is paid on only the 2 acre separated parcel, and it's removed from the program as not meeting the 10 acre requirement. This potential scenario gets almost no discussion, very little acknowledgement, and presumably little use. Everybody talks about the residential lot exception to the split off rollback, but this is equally at least it's set up. Obviously, it's not as income generating because you're selling a lot that is going to be, too small to probably produce, any sort of agricultural commodity, et cetera. It's probably going to be in the ag reserve category, or it could be just a forestry lot. But it's a wood lot. You can still have 2 acres of wood lot and not suffer that much economic consequences from it. And of course, ultimately when the house gets built, then it becomes, a split off for a residential lot. Okay, so that's a good thing to know because that's kind of buried in the law. It doesn't now separation's good. Here's what separations, basically result in. The owner of the land subject to preferential assessment may separate land. In other words, okay, I got, 100 acres of farm. I got 2 other people who want to, farm, and I'm going to convey, 30 acres to each of the other 2, and I'm going to hold on to my 40 and keep farming, or, whatever the circumstances might be. I should probably put that in hundreds of acres, not tens of acres, but anyway. If a separation occurs, all tracts formed by the separation shall continue to receive preferential assessment unless, and here's where things get dicey, within 7 years of the separation, there's a subsequent change of use to one that's inconsistent. So if you had the scenario that I was talking about, let's say you had, again, small acreage, but you had 100 acres, you got 2 people who, beginning farmers, maybe they're your kids, whatever, convey 30 to one, and they're going to continue to produce ag commodities. You convey 30 to another, and they're going to continue to produce ag commodities. You keep your 40, and you continue to produce ag commodities. Great. Except what happens when one of them says, I'm not making a very good go at this. I'm going to divide this, after a few years, maybe not 7, but 5 or 3. I'm going to, divide this 30 acres up, into some building lots and sell it. Then you got some issues. Because the program doesn't, it doesn't provide, until I show you what comes up here in the next slide, that's not fitting into these little rules. So in normal circumstances, okay, such subsequent changes in use by, again, the party who wanted to convert their 30 acres to building lots shall subject the entire tract so separated to rollback taxes. And you should read this. It means entire tract that was separated. This is really, bad language in this little section. Read it as the entire tract enrolled and subsequently separated is subject to rollback taxes. The landowner who changes the use, the person that took the conveyance of those 30 acres, shall be liable for payment of rollback taxes. What that means is a separated tract, frequently has a new owner. So that new owner can be liable for a large rollback of tax savings realized by the prior owner. In other words, depending on where they are in the 7 years progression, there may be a really large bill for, essentially, the government recouping the tax savings, and it was the tax savings that the person you bought your property, realized. It wasn't even the tax savings that you realized. So, it was realized by the prior owner, not the owner who's changing. So the bottom line is this is where there's a little bit of a tentacle reaching out that can hang around for a while. After 7 years from the date of separation, only that portion of the land which has had its use changed is subject to rollback taxes. So what's the lesson here? The conclusion: after 7 years after a separation, that's when all the strings are unattached. That's when finally, things are free and clear to essentially be dealt with as freely alienable property, at least as to the other parcels that were part of the separation. The person who's changing their use still has to pay rollback on theirs after 7 years. If they do it before 7 years, they got to pay the rollback that essentially was on the entire parcel or for the entire parcel that their piece came from. So hopefully I explained that well enough. Sorry, maybe it's a little bit late in the webinar for me to be as clear as I should be. Now, there's lots of leasing options also in the clean and green, which we can talk about in our next drill down in more detail. There's a lease. You can lease if you're enrolled. These are essentially not considered changes of use if you stick to the terms of them. You can lease for cell towers. You can, in fact, lease or have people who own the mineral rights, which would be including you, perhaps as the owner, explore and extract, oil, gas, and coal bed methane. And there's various ins and outs of that. I remember being intimately involved in drafting all that language. I've forgotten probably more about it than I did, than I knew back when I did it. So in any event, essentially the bottom line is you drill the well, and then when it's done, and there's the final site conditions, not the under construction site conditions, then that's what the rollback is on. Just essentially on the well pad and whatever else still exists there, after either the well is producing or it's been capped. So let's see. Wind power generation, there is an exception for that. It's the rollback on the footprint of the turbine and any other associated facilities. And then there's also an ability to lease for pipe storage yards. Whoops, excuse me. Pipe storage yards, if it's less than or equal to 2 years, in other words, you can't have more than a 2-year lease. There's also a small non-coal surface mining exception, and only allows one mining permit active at any given time. This is for, various, quarrying activities of things that you might be, stone, et cetera. And again, it's rollback only on in this case, it's rollback on the full leased property. Like, for example, the wind turbine, they might lease 30 acres, but the footprint's only 10. Transfers upon death. There is a provision for transfers upon death that if you are in the right class of beneficiaries for under Pennsylvania's tax inheritance statute, then you a division that brings the lot size under 10 acres that is caused by estate, testate or intestate, administration, then you don't get a rollback. Let's see. Now, there's some provisions for other transfers and exceptions, and the one that I'm going to tell you about is there is some other language in the statute about no rollback taxes when you are doing transfers, and it can be for money. These are not just donated properties for for cemetery uses and for various trails, recreational use trails to a nonprofit corporation. Just be aware that there is some exceptions to rollback for that type of a transaction also. And then we have some cases. I'm just going to rip through them real quick. There's a case that basically reiterates this idea that you have to have an exact match, a conveyance from same owners to the same owners exactly is going to essentially not be considered a split off, even if it's a conveyance of less than 10 acres, as long as it's staying in its use. And this is by court case really, but it makes sense with the way the statute's written. As long as it's staying qualified by its use, it can be a smaller parcel than 10 acres if it is there's unity of ownership. Now, there's another case, however, that was a transfer upon, and a post-estate administration transfer of a parcel that was less than 10 acres, but because it was from the widow of the deceased, and now a son was brought in as, a transferee, that was considered to be a split off that did result in rollback. There is not a lot of case law on those other, questions about LLCs, et cetera, but I would take this, the case law that we have seen means that, it's going to be it's got to be the exact same parties, saying that, oh, well, these are the same beneficial ownerships, parties. They just created an LLC. I don't think that's going to fly. There is another case that's kind of interesting in that it just clarifies this whole idea that this, you have this lifetime limit of, 10% of the enrolled tracts, or 10-acre total for the little the residential lots split offs. That's actually what was at issue in that case. So that's the only thing that this case really says. There's another case that a guy lost some 2.8 acres in a tax sale, and that was considered to be a split off. That was not considered to be a split off. So that his other, it was something close to 100 acres, I think, did not suffer a rollback on the entire set of parcels, just because he ended up letting one 2.8 acre parcel go to tax sale, which seems a little odd, but I think the court was taking a very strict view of it was not an action of the owner, although it was strenuously argued that the failure to pay the taxes was an action of the owner. And that's it. Okay. So we will get another session put together to talk more about all of these rural enterprises and other types of uses that are not necessarily conveyances, which is what this hour was about. So with that, excellent. I will bid everyone adieu, and thanks for
Thank you so much, Brooke. That was great. If anyone has questions or you have any problems with anything, email me at aet17@psu.edu, and we invite you to join us next month in March 22nd for the basics of organic production, and then back in April for the basics of producer protections for buyer default. And with that, we'll say good afternoon and have a great weekend. Bye, everyone.